welcome back to our conference after lunch. So, after we heard in the previous panel about the drafts and the projects and the discussions here in Italy, we will now turn to Germany, which we already mentioned in the introduction and in some of the interventions we had, and discuss about the Völkerstrafgesetzbuch, the Code of Crimes Against International Law, which entered into force more or less 20 years ago, drafted by a working group of experts established by the Federal Ministry of Justice, unanimously adopted by the members of Parliament, and, as we may remember, proudly presented by the Ministry of Foreign Affairs and the government as some form of a model code. And what is interesting for us today and for our meeting here in the context of our conference is how this piece of legislation developed throughout the past 20 years, which are the trends, which are the shortcomings, and in what regard have there been calls for reform. And I'm very happy to have here on the panel four of the premium experts on the topic from Germany, three here physically on the panel, one remotely. We will just continue like we did before. We will have an input and then some comments. So I'm very happy to welcome Boris Burghardt, who is a visiting professor in criminal law at Humboldt University zu Berlin, and worked a lot and wrote a lot about the Völkerstrafgesetzbuch. And so I'm very happy, Boris, to have you here, and the floor is yours.
Thank you, Florian. Thank you, Chantal, for setting up this conference and for having me. I have to admit that I found myself in a bit of a dilemma when preparing my contribution. I would have liked to focus on the recent developments and problems in the prosecution of crimes under international law in Germany. However, I understood from Chantal's email that this panel, and particularly my input, is supposed to set the scene for our later discussions, and so some kind of general introduction to the Völkerstrafgesetzbuch is necessary. So in the end, I had to accept that in the 20 minutes that I have, I will have to limit myself to a concise presentation of the German Code of Crimes Against International Law, as well as a resume of how the practice of prosecuting crimes under international law has unfolded in Germany in the last 20 years. Florian has already mentioned that the Völkerstrafgesetzbuch forms part of a larger package of law that became necessary with the ratification of the Rome Statute by Germany. It was meant to implement the material law of the Rome Statute into German criminal law. For this purpose, as already mentioned by Florian, the Federal Ministry of Justice established an expert working group in October of 1999, which handed over its working draft in May 2001. All political parties welcomed the project, and so the code was passed unanimously in the German parliament in March of 2002 and came into effect on June 30th of 2002. In 2016, the crime of aggression was incorporated in a new section in order to make the code compliant with the Kampala amendments to the Rome Statute. According to the official explanatory memorandum, the Völkerstrafgesetzbuch intends to achieve four aims. The code was meant to comprehend the specific wrong of crimes under international law. In essence, that meant that the Völkerstrafgesetzbuch was to amend the lack of implementing the Nuremberg law in the decades before. Germany had no provisions on war crimes or crimes against humanity. Only the crime of genocide had been implemented. Second, the Völkerstrafgesetzbuch was intended to promote legal clarity and practical application. This meant that it was felt that the law of the ICC statute had to be molded and modified a little bit in order to adhere to certain constitutional principles of German criminal law. Moreover, the expert group was convinced that German criminal law doctrine would help to draft a better version of the Rome Statute, so to speak. So two of the most notable deviations of the Völkerstrafgesetzbuch from the ICC statute may exemplify this. In view of the expert group, the doctrine of command responsibility of Article 28 of the ICC statute was an example of rough justice that unduly mixed together various situations of superior's omission without taking into account the varying degrees of guilt of the superior, and therefore it was decided to split up Article 28 into three separate provisions. A second notable diversion of the Völkerstrafgesetzbuch from the ICC statute concerns the law of war crimes. Here, systematic concerns led to a complete restructuring. War crimes in the Völkerstrafgesetzbuch are classified primarily with regard to the target of the attack, not with regard to the international or non-international nature of the armed conflict. The third aim of the Völkerstrafgesetzbuch was that it should ensure that Germany was always in a position to prosecute crimes over which the ICC has jurisdiction. Basically, the aim was that Germany was able to fulfill the requisites under the principles of complementarity in order to secure that no German citizen would ever end up before the ICC. Finally, the creation of the code was intended to contribute to the promotion and spread of international humanitarian law. The Völkerstrafgesetzbuch is carried by the idea that blending the material law of the ICC statute with principles of German criminal law would make for a better version of ICL and could thus serve as a model code for the implementation processes in other states. I would like to mention two more structural features of the Völkerstrafgesetzbuch. Notable is Section 2 that provides for the application of ordinary German criminal law when no special rules are created by the Völkerstrafgesetzbuch. Thus, the German legislator refrained from implementing the general principles of the ICC statute on mental element, mistake, self-defense, or modes of participation. This has been a wise decision, in my opinion, because it has helped considerably in the acceptance of the Völkerstrafgesetzbuch by the German judiciary and German criminal law scholars. Even though the crimes of the Völkerstrafgesetzbuch were new and a little different from the law, German prosecutors, judges, and criminal law scholars were used to it normally, to apply normally. It wasn't too far off. German lawyers could make sense of it, make it their own, so to speak. In a historical perspective, this was a key difference from the failed experiment to implement international criminal law into German criminal law in the aftermath of World War II with Control Council Law number 10. The most important regulation with regard to the practice can be found in Section 1 of the Code and Section 153, litera F of the German Code of Criminal Procedure. Section 1, Sentence 1 of the Völkerstrafgesetzbuch decrees the applicability of the universality principle to all crimes defined of the Code, even when the offense was committed abroad and bears no relation to Germany. The exception to this rule is the crime of aggression. As you know, the adjudication of international crimes by domestic criminal justice has been evaluated along the lines of two different approaches, distinguished by Maximo Langer: the global enforcer approach and the no safe haven approach. Now, I don't like the global enforcer label because, in my opinion, this doesn't frame this approach in an appropriate way. Instead, I prefer to call this approach the international solidarity approach, because at the heart of this approach lies the understanding that in order to work, international criminal justice has to be administered on a multitude of levels by a multitude of actors, and it is simply not enough when third states only care about those cases which bear some kind of additional link to them. And this is decidedly not the same as to claim that one state will step in always and globally ensure the enforcement of international criminal law, as the global enforcer label suggests. Now, it is obvious that Section 1 of the Völkerstrafgesetzbuch recognizes this idea of international solidarity in the prosecution of crimes under international law and declares explicitly that the Völkerstrafgesetzbuch serves the purpose to prosecute also crimes that bear no relation to Germany. However, Section 153F of the Code of Criminal Procedure, a long and complicated rule, scales back this commitment even though it is unclear from the text of the provision to what extent exactly. But what it comes down to is that in the end, in those cases where there is no domestic connection to the commission of the alleged crime or the alleged perpetrator, there is some kind of discretion to abstain from investigating and prosecuting these crimes. Summing up, Section 1 opens up the space for an ambitious practice of prosecution of atrocity crimes by the German judiciary, while the procedural rule, Section 153F, allows for boiling down this possibility to a self-serving, not in my backyard approach. Last thing about the legal framework of the Völkerstrafgesetzbuch, the competent authority to investigate and prosecute is the federal public prosecutor, not the regional public prosecutor offices, as would be the case in ordinary crime scenarios. There's one central office to investigate and prosecute all cases where crimes under the Völkerstrafgesetzbuch are alleged. Charges are brought before the higher regional courts, the Oberlandesgerichte, more precisely before the Staatsschutzsenate, special panels that normally deal with crimes against state security, mostly terrorism cases. Finally, a key piece within the infrastructure of investigating and prosecuting international crimes in Germany is the Zentralstelle für die Bekämpfung von Kriegsverbrechen und weiteren Straftaten, nach dem Völkerstrafgesetzbuch, the Central Office to Combat Crimes Against International Law, as part of the Federal Criminal Police. And with this, I would like to change and look at the practice of the Völkerstrafgesetzbuch. 20 years in, we can distinguish three stages of prosecution. Florian has suggested that the last stage, the actual stage, could be labeled towards complementarity preparedness. Well then, the adequate label for the first stage is, I guess, complete unpreparedness. Until at least 2009, both the federal public prosecutor as well as the Zentralstelle within the Federal Criminal Police lacked the personnel to conduct any meaningful investigations. And in these years, the only visible activity consisted in supplanting public complaints brought against high-level suspects by NGOs. The most notable case was the complaint against Donald Rumsfeld and other functionaries of the Bush administration for the US torture and rendition program installed after 9/11. In these years, representatives of the federal public prosecutors were, in my impression, more or less overwhelmed and constantly in a passive-aggressive mode of defending their own inactivity. The most significant outcome was that the higher regional court of Stuttgart declared that the federal public prosecutor enjoyed indeed a large amount of discretion in deciding whether to investigate and prosecute an international crime with no direct link to Germany, and that moreover the decision of the public prosecutor to abstain from prosecution with regard to section 153F of the Criminal Code of Procedure was not subject to judicial review. In the second phase, the federal public prosecutor, after gaining sufficient legroom and now equipped with a proper war crimes unit and more personnel, was able to better explain their line of thinking, which basically consisted in buying into the no safe haven approach and largely neglecting the more ambitious vision of Section 1 of the Völkerstrafgesetzbuch. In essence, the no safe haven approach came down to a only low-cost cases please approach, which also encompassed cases where indeed a direct link to the crimes alleged was present, such as cases against soldiers of the German Bundeswehr. So this stage of the prosecutorial practice is basically characterized by a very small number of cases where conducting these cases would not lead to any significant political stir-up. In cases where the federal public prosecutor was confident that no political backlash would come from it, it was even willing to conduct so-called structural investigations, that is, broad preliminary investigations without specific suspects designed to gather evidence related to potential crimes that could be used in future proceedings. The third stage of prosecutorial activity starts roughly in 2015 and is characterized by a huge increase of the number of cases where crimes under the Völkerstrafgesetzbuch are being investigated and prosecuted. This stage has to be seen in the context of the ongoing war in Syria, the activities of the terrorist group Islamic State, and the continuing armed conflict in Afghanistan. Three batches of cases can be distinguished in this regard. The first one consists of men who have participated actively as a member of armed groups in these conflicts, mostly as members of the IS or some other Islamist militia. These are German citizens or persons that had been living in Germany before and came back after a couple of months or even years, but also refugees who sought shelter from these conflicts in Germany. The second batch of cases consists of women who went from Germany to those regions under the temporary control of the IS in order to marry ISIS fighters and lead a household there, including in some cases enslaved Yazidi women or girls. Finally, the federal public prosecutor has investigated higher-ranked personnel involved in the larger scale organizations and commission of crimes against humanity, including some functionaries of the Assad regime or ISIS commanders. It is important to highlight, though, that these three batches do not carry the same weight in the actual practice of the German judiciary. Practically all of the cases brought to trial concern cases from the first two batches. In these cases, German courts have stretched the scope of application of war crimes well beyond personnel that has been convicted for international crimes ever before. It is also important to note that in these cases, the charges brought against the accused consist not only of war crimes, but mostly also of criminal membership in terrorist organizations and of the crime of illegally carrying military weapons. Thus, in these cases, we can observe a strange convergence of ICL with anti-terrorist law that, in my view, is highly problematic for a number of reasons. From the third batch of cases, there's rather little to show for. One disclosed arrest warrant from June 2018 against Jamil Hassan, the head of Syria's Air Force intelligence. Apparently, a small number of undisclosed arrest warrants against other high-ranked suspects. 3 suspects have been arrested in Germany and accused for participating in Assad's torture programs. 2 of them have stood or are standing trial before the higher regional court in Koblenz. One of them has been convicted for assisting crimes against humanity. And finally, the case of Taha A.G., an Iraqi national IS member that stands trial for genocide, crimes against humanity, and war crimes with regard to the Yazidi population. But even these 2 cases, the ones who were implicated in Assad's torture program and the case of Taha A.J. are a little bit particular and do not really fit the mold of high-ranking functionaries. So summing up the practice of the German Völkerstrafgesetzbuch until today, it is clear that the number of cases has increased considerably in the last years. And it's also true that the prosecutorial efforts of the federal public prosecutor are not limited exclusively to a no-safe haven approach. There are structural investigations going on, and there are occasional investigations and prosecutorial measures taken against individual suspects, although the alleged crimes and suspects do not have any link to Germany. On the other hand, however, the prosecutorial practice is still far from the more ambitious vision that was sketched out in Section 1 of the Völkerstrafgesetzbuch. The most influential guiding principle of the federal public prosecutor still seems to stick to low-cost cases, which of course add little or next to nothing to the larger project of ICL, ending the impunity of large-scale atrocities. Rather, the recent application of the Völkerstrafgesetzbuch raises some concerns of overreach. Thank you very much.
Yeah, thank you so much, Boris, for this excellent presentation, highlighting actually in this very short time all the major developments and observations we can perhaps if you like, discuss a little bit later during our debate. But before that, we now come to our second panelist who joins us online, Wolfgang, who is a political scientist, historian from Marburg, from the University of Marburg, where he serves as the managing director of the International Research and Documentation Center for War Crimes Trials. And yeah, we are very happy to have you with us, Wolfgang, and the floor is yours.
Yeah, thank you so much. Do you understand me good? Is the sound okay?
Yes, it's fine.
Okay, wonderful. I would like to thank Boris first for his description on current status and prospectus of the Völkerstrafgesetzbuch, and I fully agree what he was to say, and I would like to comment in a few other and different aspects, also from a political and social science perspective. If there is any overlapping in my talk to other comments on this session, please be patient. That has to do that we didn't really check up before what we want to say. On one of the major problem area of the Völkerstrafgesetzbuch is the influence of the politics on the proceedings. Let's face it in this way. If foreign policy concern, in the particular speak against prosecution, like the named section 153F of the German Criminal Procedure Code, then the prosecutor's office can refrain from the prosecuting. This initially means two things. First, prosecution is not only a response of a criminal act, but also owned to the prognosis of the conduct of the trial. Second, choose the political has a mean of the intervene in a negative way all through on the offense in present. In an extreme case, that would mean if a trial for genocide would run counter to Germany's interests, there would be the possibility of refrain from a prosecution for the reason, if it were cited that the perpetrator would not come into Germany or will live here. That would mean first, states with great international influence, let's say the US or China, can count on the fact that against its citizens related to trial would take place in Germany because a potential perpetrator would not enter the border of Germany. Second, the criticism of the international criminal law to focus rather on less development states is promoted. That is not to support the often emphasized American burden of the ICC work. Rather, in this means to success that the image of a class justice may be condensed at the international level. It's debatable whether this genesis of the Völkerstrafgesetzbuch and the provision of the section 153F of the Criminal Procedure Code actually involve the classification in this context. What happened? Initially, the intention was imperatively to refrain from the prosecution in the aforementioned context. This has been waked into a wording into can provision. However, this makes it possible to stop prosecution. In many opinions, it remains possible to restrict the principle of international law. In some way, it can be said that the principle of international law has been theoretically and partly withdrawn because they can be exception in the end of the day. It is interesting to note that in other constellations, membership of a criminal organization, Boris was talking about that, but not in proceeding under international criminal law, Völkerstrafgesetzbuch, serious, dangerous, or disadvantages for Germany can be taken into account. That is ruled in section 153C in the Criminal Proceeding Code. and stops investigations. The raises of question of the scope of impunity in different legal contexts could be discussed later on. The criticism of double complementarity cannot be dismissed out of hand either. In certain cases, prosecution is independent on the access of the ICC or national courts of another states. The problem lies less than the jurisdiction of the ICC than with the national courts. In this context, it can be critically noted that proceedings in Germany are discontinued or even not be started, although they could have been tried. Whether this is a really or a counter argument would be discussed maybe today. Dear colleagues, allow me to address some other aspects. Already in proceeding according to section 228 German Criminal Code, that's the genocide law before the Völkerstrafgesetzbuch come into force, it became clear that the trial for away from Germany leads to first logical, three cultural, and third linguistic problems. And of course, in the national cases are mostly very expensive. For the logistical part, in contrast to proceeding at the ICC, German authorities have significantly fewer opportunities to conduct on-site research in some countries. Within witnesses, interviews are therefore even more difficult to conduct than is already possible in ICC proceedings. If a difficulty get access to assistance from foreign national investigation authorities, requests for assistance could be more difficult status than, for example, assistance under the obligation of member states of the ICC. In the so-called Rabo-Combe case under the section 220A, it became clear that there was something, discrepancy in prosecution of the accuracy or validity of witness statements. This can be, of course, also be the case in proceeding under the Völkerstrafgesetzbuch. This was evident, for example, with regard to knowledge about events. For witnesses from Rwanda, for example, it was less of a problem to assume knowledge about events, even if they were secondhand or hearsay evidences. For the witnesses, it was partly irrelevant whether descriptions has been experienced by themselves or has been communicated by other persons. According to the motto, why should I not believe the storyteller? In summary, the findings can certainly be assigned to the fields of cultural differences. And how to deal with this would definitely have been determined in more detail, maybe today or tomorrow. In cultural studies, there is often talk at this point of a so-called Euro-centered or Western-dominated view of world, and the world ignore other perspectives. It cannot be say how the German jurisdiction will behave in such cases in the future, but it is still a problem. Without questions, language problems are always a special challenge. As long as we are dealing with, let me see, widely used languages, there are mostly no differences. But with lesser known or local languages, this can become more difficult. Not only can it be a challenge to find translators, the language themselves became a barrier of communication. Just as an anecdote, during my visits in Cambodia, it was confirmed with me that Khmer, that's the local language over there, does not actually know the word for genocide. It is only a matter of a few vocabulary words. This is not really a relevant thing. But however, when it comes to linguistic syntaxes, then this can become more complicated. Descriptions, comments can certainly change their meaning in the translation or the transmission of translation. Language is always evident in a process of cultural and social references, not only in terms of reading between the lines, but also in terms of a priori attributes that cannot be easily translated. So far for the moment, my comments to Völkerstrafgesetzbuch 20 years after Trends, Shortcomings and Reform. Thank you so much.
Yeah, thank you so much, Wolfgang, for adding these very important perspectives to the picture we're trying to draw here on the experiences we have in Germany. So our next speaker, Wolfgang Kaleck, he is a lawyer and the founder and Secretary General of the European Center for Constitutional and Human Rights in Berlin, a center which many of you may know, and a center which has been instrumental in pushing, if I may say so, pushing the prosecutors to apply the Völkerstrafgesetzbuch. Wolfgang, please.
Yeah, thank you very much, Chantal and Florian, for the invitation, and hello, everybody. Yeah, I had the pleasure to bring cases, or try to bring cases, before 2002, before the Völkerstrafgesetzbuch was established. It was the Argentinian dictatorship cases. I even have the privilege to work on colonial crime cases 100 years ago. And now I did some of the cases Boris mentioned, the Rumsfeld case and recently the Syria cases. And interestingly enough, there are some experience which I can generalize. That is not to say that the normative basis doesn't matter. It does matter if it's a case before 2000 or after 2002. But it is to say that the truth is concrete. And a lot about international criminal justice is about the practice and the struggles in the practice. And there, this is more or less my perspective. And I agree with Wolfgang Form that there are a lot of provisions which allow a lot of influence of politics on the practice of international criminal law in Germany. But you have to be aware that the Federal Prosecutor's Office in Karlsruhe strictly denies that. They would be very eager to maintain the fiction of neutrality, and they would try to maintain the idea that they are only taking decisions on judicial ground. So this might be one reason why not only the prosecutors, but also a lot of the big bulk of the academic community and even NGO community buys into this argument and tries to frame their own arguments as neutral, as apolitical and only legal. And so there is no real politics of international criminal law in Germany. And I think that's definitely a missing piece. And that brings me to Boris, your short run through the recent history of the last 20 years, which I can basically agree to. I have only a couple of remarks, and one is I agree that there are so-called low-cost cases, the safe haven cases. And I also agree that it's necessary to relate these cases to the larger project in Germany and to the larger practice of ICL in Germany, but even moreover to the global project of ICL. But you have to be aware that cases like the current Syrian cases you were referring to, Boris, especially the case at the High District Court in Koblenz, Oberlandesgericht Koblenz, is absolutely crucial for the Syrian community, for the exiled Syrian community. So yes, it's important to develop a certain critique of a very selective practice of international criminal law, but one has to be aware that these Syria trials, the first judgment in February, and the next is about to come probably in November, December, January, was a huge effort by first the Federal Prosecutor's Office that you both of you, Florian and you, described it as a certain kind of preparedness. You said international solidarity. I would say it's a division of labor. It's what they call antizipierte Rechtshilfe, anticipated legal cooperation, means whereas prosecutors before had this idea, it's only about my cases. The only cases which are interested are the cases which I can bring to court, pursue at court, and can reach a judgment. Now they have a better understanding of the broader picture and are aware of the fact that some pieces of a case they might carry out in Germany, whereas other will continue in The Hague or in Paris, and later on it ends up in a trial in Syria or in the region. So that is in fact a big step forward. And due to this idea, they spent huge amount of resources into the investigations, including the forensic analysis of the famous Caesar files, the pictures of the dead bodies, where they spent nearly a bit more than $1 million to investigate. And the clear message is we do it not only for the Koblenz or similar cases. This is the work we do for, let's say, the overall project of ICL. So if another European prosecutor needs access to our analysis, we give it out. So it's a push for the project of universal jurisdiction in Europe, but not at all pretending that this is going to be a solution. They are aware of the fact that the ICC or a Syrian transitional justice project would be much more appropriate, but as this is missing, they step in. And I think this is an important step forward, but obviously not necessary. For the Syrian community, it cannot be overestimated what it means for them. It means, in a way, an icebreaker case. It means that the fiction of impunity, which is not only a legal fact, but it's also a social and a psychological fact, the fiction of impunity could be broken. And therefore, we have huge discussion with this community about what means justice, and we all agree from our side, but also for their side, this is obviously not justice. Justice cannot be done in the face of such crimes, but it's a piece of justice. It's a step forward. It's definitely more than nothing. It's a step out of the complete unimpunity. So that's the first remark to you. And the second remark is, I agree with you, and also the tendency, the marrying of ICL charges with terrorism charges. And but I would like to focus a bit more on the missing piece. And the missing piece is the crimes of the powerful. And we can, no matter which you said, we have to look at the multitude of levels and actors, and the larger project of ICL. So that's not only universal jurisdiction cases in Germany and Europe, that's also the politics of the International Criminal Court, especially the office of the prosecutor. And there the outcome after 20 years of this broader project is poor, is really poor, and moreover, it puts completely into danger the whole project, because as long as only African cases and low-cost cases are pursued on every level of this international criminal justice system, less and less states and less regions accept anyhow the legitimacy of the whole project. And the legitimacy of the project is the basis of the project. And if this is not accepted, we can forget this project. So what is, for example, missing in Germany, whereas there are huge and important investigations into the criminality of the Syrian Assad regime, at the same moment, the prosecutor denies with very, very poor, and we can go deeper into that, with very, very pure arguments, for example, cases against technology providers, surveillance technology providers, who exported even when it was clear that this technology is used for systematic torture. So they denied even the opening of an investigation into German technology firms, as well as they denied the opening of cases against German arms traders because of aiding and abetting war crimes in the Yemen and in other wars. We keep on, my organization and networks of other organizations are keeping on to bring cases, and this is something I would say deserves a little bit more attention of the academic community, because at the same time that the prosecutor's office in Germany shows more openness, they are now in a way communicating with NGOs, with the academic community. So they pay more and more attention to these arguments because they want to be accepted. They want to be accepted as part of this community. And as more important it would be if this community also puts the finger in this wound and urges them and backs also them if they go into cases against the powerful, because obviously this is not only a struggle or a debate amongst the legal community. This goes into a level of society, of politics, where we have to communicate to a broader public, to trade unions, to enterprises. For example, in the case of forced labor and war crimes in the Uyghur region in China, this is very clear. This is about our model of consuming. This is about global supply chains, and this obviously needs a political debate, and it's not only a legal debate where all of us here and many more people are important to move this debate and to shape the politics of international criminal law. Thank you.
Thank you very much, Wolfgang, for your presentation. I'm sure we will come back to some of the issues you raised in the debate. So I'm sorry to say, but to our and his regret, Gerhard Werle cannot be with us here today, but he had to cancel his trip and even an online participation due for health reasons on quite short notice. So he sends his greetings to many of his friends who he was looking forward to meet here. This means that we already come to our final speaker, Leonie Steiner. She is a senior researcher and lecturer in criminal law at Humboldt-Universität zu Berlin, works a lot on international criminal law and transitional justice and issues like that, and I very much look forward to your presentation.
Thank you very much. The good thing about going last is that a lot of important points have already been made, so I can build on what Boris and the two Wolfgangs have said so far. And I would like to focus on three challenges. The first one is the asymmetrical application, which we've already heard a lot about. The second one is the need for specialization and training of the authorities. And the third one is blind spots in German substantive law. On the first point, what we've now, I think, made abundantly clear in the panel already is that we can observe in the German international criminal law practice a sort of asymmetrical application, a focus on small fish, usually non-state actors, proceedings with low political follow-up costs, and usually actors from the global south. And this is not to say that these cases are not important. I think it was really good that Wolfgang pointed out the importance to the Syrian community, to the survivors, and to the diaspora, of course. But it reminds us of the criticism of selectivity, a particular form of selectivity that has been voiced in particular from a third world approaches to international law perspectives with regard to the ICC, but of course this also applies to the German international criminal law practice. And I also would like to re-emphasize the point that the main drivers behind an equal application of international criminal law in Germany are in fact NGOs, in particular ECCHR. And this applies not just to the actors who are targeted, so meaning that NGOs are pushing for prosecutions beyond small fish towards powerful states, towards powerful actors like corporate actors, but it also concerns the crimes that are prosecuted and how they are prosecuted. And to give you a concrete example of the latter, in the Al-Khatib trial, for instance, sexualized violence was only charged by the federal prosecutor as domestic crime under the German criminal code. So the other crimes are charged as international crimes, but not sexualized violence. And this was only amended after an intervention by the accessory prosecution with the support of ECCHR to reflect, of course, the injustice of this harm. And this is just to highlight the important role of NGOs in the international criminal law landscape on a domestic level. And I think one possible way to counteract the asymmetrical application is through an effective control of non-prosecution decisions by the Federal Prosecutor General. So this is currently only limited, this control, the actual discretionary decision under the rule section 153F of the German Code of Criminal Procedure. The discretionary decision as such is not justiciable. So I think this should be amended, for instance, by having a judicial approvement requirement in order not only to follow the example of the Rome Statute, but also because it would make the asymmetrical application more visible and could possibly even counteract this. Now to my second point, which is actually related to this and which concerns the need for sufficient expertise amongst prosecutors and judges. This requires, on the one hand, I think, a degree of specialization, and on the other hand, it requires training. Specialization on the prosecutor's side, I think we've seen this in many states across Europe, has been proven essential in ensuring the effective prosecution of crimes under international law. I personally would also find it interesting to have an increasing specialization of the judiciary, and maybe that's something we can discuss later on. But I think equally important as the specialization is training. And I mean by that training for prosecutors and judges with regard to international criminal law, but not only substantive and procedural international criminal law, but also broader issues like a critique of international criminal justice, and also the principle of gender-sensitive and non-discriminatory proceedings, like measures to avoid secondary victimization, but also on the needs and rights of victims of international crime. Because the latter is, I think, an area of concern, which is often not given the due attention. It must be ensured, of course, that victims of international crimes can participate effectively, that they're informed and updated, that they have the necessary support, and that they also receive reparations. In Germany, we have a lot of instruments like accessory prosecution, psychosocial trial support. We also have some measures of compensation, but in practice, the victims often don't know about their rights. They are not updated on the proceedings, and they do not receive any reparations. So I think this is also where training of the state authorities will become very influential in order to ensure that they can actually fulfill their obligations under international law. And this brings me to my third and last point. Now, I've mostly talked about the need for a knowledgeable, willing, and well-resourced state authorities, prosecutors, and judges with sufficient expertise in international criminal law, and then secondly, on procedural international criminal law. And now I want to touch upon an issue in substantive international criminal law, because of course, substantive international criminal law is as important as having the right, or as important as having the right tools in actually effectively prosecuting these crimes. And I want to highlight some blind spots in the German Code of Crimes against international law, which actually would warrant some legislative attention, in my opinion. And this concerns the area of sexual and reproductive crimes under international law. We've seen here in Germany actually a very important reform of the crimes relating to sexual violence and rape in 2016. So of course this has also changed the framework on which the VStGB, so the Code against international criminal law, relies, which I think raises a number of complex interpretation questions. But we also see that the VStGB is not fully in line with the requirements of the Rome Statute of the International Criminal Court and the newest jurisprudence in this regards. And I think this is interesting because usually the Rome Statute and the jurisprudence were, I think, very progressive, more progressive than the German legislation, but now, of course, it's also 20 years old now, the VStGB, but now we see this changing slightly in this instance, for instance, but also, for instance, with the provision or the definition of gender in the Rome Statute, which is more conservative than what the German law actually defines as gender. But in terms of the VStGB and its substantive law on crimes against sexual and reproductive autonomy, we have the following problems. In the VStGB, we do not have a crime of sexual slavery, so the specific harm of that crime cannot be adequately captured. We do not have the other sexual acts of comparable gravity, because there was, it was held that this would infringe upon the Bestimmtheitsgrundsatz, the principle of legal certainty, which also means that we have gaps such as forced nudity, but also forced abortion, which cannot be criminalized as such under German VStGB. And lastly, we only have the crime of forced pregnancies in a much narrower context than we have it in the Rome Statute, because under the VStGB, it requires the intent to influence the ethnic composition of the population. and not like in the Rome Statute, where we also have a second requirement or a second option, which is the intent to commit serious violations of international law. As a result, the very recent ongoing conviction would not hold in Germany. That would not be a criminal offense of reproductive autonomy under the German VStGB. And this, of course, leads to gaps, as it has been documented, that forced marriages, so-called forced marriages, and also sexual slavery without this ethnic composition, like in Cambodia, Sierra Leone, and Uganda, are in fact probably the most relevant practical constellation. Hence, I think there's room for improvement with regard to the German substantive law of the VStGB. And Florian Jeßberger, in his introductory remarks, mentioned we can reflect critically on states' experiences and on the lessons learned. These were mostly lessons to be learned, which have not been learned yet, but I hope it's still helpful. Thank you.
Yeah, thank you very much for in a way completing or providing us with a narrative after we heard quite many times this morning about the Italy being late and being incomplete. Now we learn a little bit about what in Germany is missed and what lacks there. Okay, so now we have some time for questions and answers, but I would first ask Boris, I don't know if you'd like to react. I mean, the comments were more of a complimentary nature, actually, but if you like, I would invite you to take the floor first.
Well, I don't want to take too much time of the broader discussion, but maybe just a small reaction to Wolfgang Kalek's comment. So, of course, you're right that I shouldn't have downplayed like the Syria case before the Higher Regional Court of Koblenz and the importance for the Syrian community and what it means that finally at least some crimes have now been brought before a court and some responsibles are now convicted. Nevertheless, I would say that my intervention has to be understood as maybe contrasting this with, of course, the way of the narrative that the federal public prosecutor is now trying to establish of its own activity, and maybe also, and you mentioned also to this, the danger of us as criminal legal scholars to follow this lead and then limiting ourselves in analyzing these cases from a dogmatic perspective. Because now with these cases, of course, case law is created. The case law has some interesting legal intricate problems, but I would say that in the end, the useful, whether it is useful in a broader perspective of international criminal law is still doubtful. I also want to react maybe on one thing that Leonie Steiner mentioned with regard to the section of 153F. So this procedural rule that opens up discretion, and of course, this is it is always lies at hand to see the main problem of the unsatisfying practice, prosecutorial practice in this rule. However, I would say that at least from a historical perspective, well, of course, recent history, last 20 years, but from a historical perspective, it has kind of a paradoxical effect, because I would say that, as I maybe hinted to also in my introductory comment, it helped the federal public prosecutor to also move these steps forward that Wolfgang Khalek described. It needed this kind of maybe facade where it could hide behind a little bit. It needed this kind of legroom that was given also with the decision that these prosecutorial decisions are not under judicial review in order to move forward. So at least from a historical perspective, I would say that it had also some kind of, for the broader acceptance of this whole project of German ICL, it had maybe even some productive effects. That the political opposition against German international criminal law might have been greater, and then maybe the whole project would have been shattered if the federal public prosecutor had not had the possibility to, so to speak, hide behind this procedural rule. And I stop here.
Okay, thank you very much. So, any questions from the audience? Chantal, this was a question? Yeah, please.
Also online, maybe.
Yeah, we can also take questions online. So, if you raise your hand, and someone here in the room will let me know that there is a question. But now let's start, Chantal, with your question.
Yeah, first of all, thank you so much, all of you. It was really, in such a short time, a great, I think, presentation of the last 20 years. I was wondering whether anyone has like a complete picture of those criminal complaints that the federal prosecutor decided not to investigate. I mean, I know many of them because with Wolfgang at ECCHR, I know the work inside the organization, but also some others that you mentioned. But is there any compilation that can serve now to really also analyze if there are common elements in those cases that have been in fact taken by the German prosecutor or rejected, that, because of course, I mean, it seems pretty obvious what Boris, you presented, like, okay, low-level perpetrators, but can we show it using data? And also, this is just an observation, having started to observe as an external this process of using universal jurisdiction in Germany to prosecute international crimes. I remember when I was a young PhD student at Werle's Lehrstuhl, and Wolfgang was invited there, and the federal prosecutor was invited. I remember them as being opposite. Sometimes even there was a sort of, I don't know, it was like definitely not a normal situation to just not friendly, not just a friendly conversation. And then through the years, there was a sort of shift by the general prosecutor, the federal prosecutor in Germany. You could notice that he was starting, when invited at the Humboldt University or so, to praise the work of ECCHR and of Wolfgang, and indeed, I think it is very true what Wolfgang was saying about the fact that they need to be accepted in this group. And so maybe it's time again to criticize them more on some points.
Thank you. Wolfgang, you want to react on both of the issues, perhaps?
Thank you very much, Chantal. I mean, actually we have quite an overview about the criminal complaints in Germany, as well as some kind of overview of what's happening with the communication in The Hague. And as far as we can see, many of the communications in The Hague and many of the criminal complaints in Germany are not really well founded. That's very clear. And the few which are a little bit more accurate, I also would say there are good legal reasons not to pursue these cases. So we can actually focus on very few situations which have been brought to the Federal Prosecutor's Office, and you don't need to know the known unknown. That's the first thing. But the tendency, I think, is very clear. And from the decisions they take, and from the longer and more founded argumentations where they object to open a criminal investigation, that is something that is worth to be developed. And actually the question goes then more to Florian. What happened to your project where you once wanted to document all this decision and also analyze it? I mean, he started at the Hamburg University. I guess it has been now a little bit too much of work. It becomes too much of work because actually the prosecutor is looking into more a situation because they kind of copied the model of preliminary investigations at the Office of the Prosecutor in The Hague. And so there are many, let's say, open preliminary investigations, some of which we wouldn't know because they're not publicizing everything. So I think there is a lot going on, and that brings me to your second point, the relation to them. I would say it is a step forward that they are engaged in such discourses as here. And I would have said the same, and Boris would have said the same, and Leonie said the same in their presence. And while 10 years ago they would be outraged that this is going to these kind of arguments are thrown in their face, they engage now in a critical dialogue, which is in the first. It's not immediately leading to new attitudes or a new politics of prosecution, but I think it's a big step forward compared to the situation 20 years ago.
Thank you very much. Just to add one sentence, I mean, to give you an impression of the numbers and the quantity of cases. So I just got told from the prosecutor that until now, so during the last 20 years, they opened 230 or so investigations. So this comes before the background which Boris drafted for us. So nothing happened during the first 10 years or 12 years or 14 years, I don't know. So there is this, just to give you an idea, so this was not your question actually, Chantal, but just, you know, to complement that. On the other hand, I mean, of course, I mean, I'm pretty sure there were also complaints in Karlsruhe saying Angela Merkel is responsible for crimes against humanity because of the corona measures or something, yeah? So it's also very difficult, probably statistically, I mean, there probably is a way, but even if you got the numbers of the complaints based on crimes under international law, that may be a little bit misleading. So the next one is Valeria.
Thank you. So, is it working? Yeah. So I just want to add something else that we will have in the database. That is, there is this common understanding that in developed countries like Germany, there is not so much need for NGOs to work. But then we go to ICL and we see that without ECCHR, we would not have progress in sexual gender-based violence, in communication with the victims, and in so many other aspects. So maybe it would be also nice to measure the role of NGOs as civil participants, and I don't know if there is, like there is also, this is also a question, if there is any study to measure the impact of civil society in the implementation and enforcement of the international criminal law in Germany, because I don't know, for the very superficial research that they have done, it seems that without them, it would be very little what has been done. And in particularly, I'm following with Chantal's question. I wanted to ask Wolfgang if you can expand a little bit more in these crimes of the powerful, particularly in the case of these corporations, IT corporations in Syria, using the structure that Leonie was suggesting, like substantive and procedural and even more epistemological or political arguments, which are the obstacles to prosecute these crimes of the powerful, particularly in the Syrian case. Thank you.
Yeah, I mean, first of all, I mean, we have been talking, and Boris pointed that out, that it took a long time even to come from this absolutely unpreparedness to a little bit of investigations in low-cost cases, and now entering in completely new field, this, what you call international solidarity or division of labor. So this is 20 years, and that is what? Yeah, sorry. That is something I think you have to bear in mind, that the practice of universal jurisdiction in Europe started a little bit more than 20 years ago. 1998, the Pinochet case, and afterwards, the first wave of complaints, the first experience in Spain and in Belgium and other countries, it began even later. But the same NGOs, the same civil society actors were in the end of the 90s and the beginning of the 20s not ready to file cases against their own corporations. So they're rather part of the problem than part of the solution in this regard. And so a sensible litigation against corporations was only possible in a few countries like the Netherlands and the UK, because their specialized law firms brought cases like the Trafigura case in the UK. But these were highly specialized corporations which are carrying out this kind of litigation since 20 years. So not very much going on, because not many resources are put into this kind of litigation. And that's the problem. And I mean, when you ask about the main problem, I would say the first problem is solid facts. I mean, solid factual evidence. We are talking about criminal procedures. This is not an NGO report. This is not a New York Times or a Spiegel article. Where you can assume certain things. But when it comes to a criminal procedure, we need another level of evidence, and that costs a lot. And while certain states, and I'm not talking about completely closed society, but certain, let's say, more open societies allow a certain transparency into their, even in the commitment of crimes. And for example, in the US case, the post 9/11 torture, we wouldn't have been able to file cases without the revelations gained by journalists and gained by Freedom of Information Act applications. So, but we have no Freedom of Information Act application rights towards corporations. So you are forced into open source investigations. That is important. It is, in fact, an absolutely new tool, but still, we are even less powerful when it comes to corporate actors than to state actors. And if the prosecutors are then not willing to prosecute and to, for example, to seize certain evidence from the headquarters of the companies or to interrogate some of their official, this goes nowhere. And then obviously the kind of the level of the legal argumentation is absolutely poor. Just to give you one example, in the Syria surveillance technology case, they had on their board the former chief of the Bundesnachrichtendienst, the Foreign Secret Service of Germany. But in the legal argument not to open any investigation, they would say, how would this poor small company know that in Syria they started to torture and use the surveillance technology to trace it? I mean, this is such an arbitrary argument, and there was nobody really paid attention to it. And that's the second thing, that nobody really pays attention to it. That is also something, that if the public doesn't notice it and if the public doesn't criticize it, prosecutors will continue to not throw sticks into the business, into a very important business.
Thank you.
Yeah,
But sorry, one more thing. But there are also other tendencies, and I have to mention the Supreme Court judgment in the Lafarge case by the French Supreme Court 2 weeks ago. And that is really something very interesting. That's a completely new line of possible litigation, as well as the global supply chains law in Germany is a new line. So there are some movements. It's not a stuck situation, It's a situation where it's very clear it's disputed. There are struggles around the interpretation and about the establishment of new norms. Sorry, Leonie.
Yes, just to Valeria's point, I think I also agree with you that there is surprisingly little literature on the role of NGOs in not of course with regard to creating the ICC, there's a lot of literature, also not with regard to implementing ICL, but on strategic litigation, on developing international criminal law. And I think what becomes clear, I think for all of us, it sounds pretty obvious, almost banal, to say NGOs are one of the main drivers behind this equal application or maybe in counter-hegemonic application of international criminal law and have an important role in the system. But I think it's not as clear in the literature yet. And Florian Jeßberger and I are also doing a project on strategic litigation and international criminal law. We're looking at ECCHR, but also 11 other organizations work with regard to international crimes and what effect strategic litigation has there. So hopefully soon.
Yeah, maybe just to add to this question of the influence of NGOs. So obviously I completely agree that more or less all of the if you would like to call it that, progressive understanding of international criminal law, bringing the German cases into a broader perspective. Well, all of these broadening of perspectives have been brought by NGOs, well, basically Wolfgang Kaleck and all the other people who are working at the ICCHR. However, I would also, again, in a historical perspective, point out that maybe this complete unpreparedness of the federal public prosecutor mirrors also kind of the obliviousness of the legislator at the time. That even though Wolfgang Kaleck started the work of the Coalition Against Impunity in 1998, in the legislation process, and as far as I recollect, maybe Florian can speak to this, even in the drafting process, the whole idea of civil society actors holding accountable the public prosecutor and their work didn't have much of a bearing into the drafting process. And when we compare this to similar endeavors of drafting, maybe for example the Lieferkettengesetz now, we can see that how now the political actors have or are taking into account that well, these laws will be used and we will be held accountable, and I would suspect that maybe even would have been if this perspective would have been present at the time, then maybe a section 1 of the Code of Crimes again under international law would have drafted in a different way. I don't know. I'm not certain, but yeah.
Thank you. Before I turn to Professor Wiegand, we will briefly invite, I think Wolfgang raised his hand, if I'm correctly.
Yeah, but that is a total different question. If the other participants want to be by that what we were discussed at present, please, I will ask later. Okay?
Well, I don't, is your question connected to? Well, okay, so Wolfgang, please go on with your.
Yeah, that's a question on all of you. At present, we are talking about the highest hierarchy is the federal public prosecutor. But this body is not totally independent. There is some, let me see, hemisphere above it, the central federal government and the Minister of Interior. Do you have any information about the influence of the Ministry of the federal public prosecutor at present in this special question what we are discussing today?
Thank you very much. This is quite a delicate question, which I hand over to Boris, our presenter. I assume there is a technical and perhaps a practical answer, but I don't know.
Okay, so then you seem to have an answer. Well, my answer is basically that I don't happen to know any of this. As far as I can see it, theoretically, of course, the Ministry of Justice could intervene, and we have seen in 2015, I guess, this notorious case of the treason, bringing charges against actors from civil society actors who managed a website for treason, where the Ministry of Justice has famously intervened, which caused a huge splash in the public sphere, in the German public sphere. But to my knowledge, none of these direct, open, but neither even these indirect interventions have become, well, are known, although, I mean, the most famous case would be, again, the case of Donald Rumsfeld, where it is hard to imagine that, at least informally, there were some calls going on. And similarly, one might suspect that in the case of Zokor Amatov, the former Uzbekian Minister of Interior, who was present in Germany for several weeks and who was one of the main alleged perpetrators of the massacre of Andijan, one would suspect that similar calls were going on, but
we know.
Okay, so we know. Okay,
we know that. I mean, you are right. In theory, it shouldn't. In theory, it can happen. In the discourse, the Federal Prosecutor's Office said there was no such an intervention, but we know as well in the Uzbekistan Almatov case that there was an intervention from, namely, the Foreign Office, and in the Rumsfeld case, I mean, we know what happened, that they were willing, the prosecutor's office was willing to take a deep look into the case, and then Donald Rumsfeld was supposed to come to the Munich Security Conference in February 2005, and he was saying, I'm not coming to Germany unless this case is solved, and all of a sudden, the case was closed one day before the conference was opened, and he got the fax by the embassy, and he flew into Germany. And so we even complained to the UN Special Rapporteur for the independence of judges and lawyers in this case. So, but there is also another important influence, and that you can see in a positive way in the Syria cases, when the foreign minister and other ministers are willing to invest in these cases because they serve German foreign influence. A lot more is possible, a lot more is going on, and that was crucial for the ongoing huge investigations in the Syria case. The question, resources or no resources, more or less resources.
Thank you. So,
just a very short question. In your opinion, do considerations about the amount of resources to be invested in an investigation and a following trial play a role in the decision whether or not to prosecute? And has there been a public debate on this point, put in very harsh terms, on public resources and taxpayers' money spent on this task?
Yeah, I mean, there was one absolutely annoying statement of the presiding judge in the so-called FDLR case at the High District Court in Stuttgart, where this presiding judge was complaining in the public, in his oral judgment, while sentencing Morvan Ashakya, the main perpetrator. He was saying this is not a case which belongs to German, in front of a German court. And this was well received by part of the media as well as by part of the legal community. Parts of the legal community was saying that it's a huge wasting of resources with very little outcome. And so again, 5 or 7, when was the Imora Shakya judgment?
2015.
2015. Again, another 6 years later or 5 years later, because the Syria trial began, it was no such a debate. It was the other way around. We were all prepared that even, you know, the tabloids or any, and it was the other way around. They were all very empathic. They told over and over the stories of Syrian torture survivors fleeing into Germany, being received, you know, after 2015, and kind of supporting them in their claims. So this was also a shift in public opinion, which is notable.
Yes, I would also say that this it was a brief, well, discussion or stir up in the second phase of the prosecution, where not only in the FDLR case, but also in the case of a former Rwandan mayor who participated in the genocide of the 1990s against the Tutsi, was prosecuted and finally convicted and sentenced before the Higher Regional Court of Frankfurt. Of course, this was not a case under the Völkerstrafgesetzbuch because the crimes had been committed earlier. But in both these cases, media reported how much the trial had cost and how much money had been spent. And like Wolfgang said, this caught on a little bit in the media, but not really on a political level. So as far as I can remember, it never. I mean, the latest. Kleine Anfrage, so the questions posed by members of the German parliament of the far right-wing party AfD went also along to point a little bit out to the costs and the resources being invested in this Syrian cases, but you can almost say that if the AfD brings forward these things, yeah, it's a good sign, because then it's basically not debatable for the other political parties.
And can I just add on that? I think also that's the last point I find important. I mean, the self-conception of Germany as building on the Nuremberg legacy is what this is all centered on, right? And so I think questioning this is really then the AfD. It was actually questioning if we should be doing this, but of course it builds with the conception of what Germany wants to be known as or wants to be like.
So thank you. Chantal, can we take another question, or I don't know. So in the back. Thanks.
Here.
Is it on? Yes, it's on. Hello, everybody. Two small observations, one tying in with what Ms. Steinl said, and that was a good observation, I guess, that you should not only make efforts to centralize your prosecutorial offices, which has been done, but also try to improve the expertise of the judiciary. And I think that's a very good idea. Have there been any initiatives in this point to come up with one particular chamber which engages with international crimes? In Holland, perhaps you know this, we have one chamber in The Hague, and there's a separate one on surrendering in Amsterdam. So that might be a good idea. Perhaps it is prevented by the scope. Germany is a larger country than Holland, that's for sure. So, but that's something to think of. And tied with that is my second observation, small observation. If you complain about the lack of symmetry, I completely agree, but sometimes you should have to realize perhaps that it's a question of contingency. You have to act very quickly, because I understand that in Germany it's a requirement that someone has to be on your territory in order to exercise universal jurisdiction. The same, is that not true anymore? Has that been?
No, this falls. Okay. I would say that this falls under the discretion policy of the federal public prosecutor. The standards of the law allow for investigating and prosecuting cases regardless of any link to Germany, but in these cases, well, based at least on the reading of the law, how the public federal prosecutor applied the law, he can abstain in these cases.
Right.
Bearing some
so
other
it's possible.
prerequisites.
Yes. So you abstain from applying the legalitätsprinzip, more or less, in that case.
So the practice is that there have been cases without a direct link where the federal public prosecutor has investigated crimes under international law. Yeah.
But yes, even then we spoke about corporate liability. Well, the Germans still do not recognize corporate liability, if I'm not mistaken. You're making attempts in that direction to apply punitive administrative law. And of course, there's always the problem of personal immunity. So if someone has left office, it's much more easy. But then it's often a contingency whether you have someone on your territory. We had this famous case in Pinochet 25 years ago, even before the famous Pinochet case in the UK, that the bird had flown. And so we require the presence of the culprit on the territory. So we had no jurisdiction anymore. So that was a grave problem. So my point that I want to make is that one should not underestimate the great problems that are extant when you are especially going after the higher in office.
Thank you very much, Harman. I take this more as a comment, and perhaps you want to react, but I want to give the opportunity to Professor Burghardt to ask a final question, and then we have to conclude.
Thank you. This was quite interesting, all the debate. I was there are two questions. One is a comment on the question of the Rwandan guy. I think that is quite special because it comes into the cooperation with the ICTR, which comes from an obligation under the UN Charter. I mean, this was a decision to prosecute these people taken under Chapter 7 of the Charter, and it's true. It's the ICTR that decides. But the ICTR can decide whether to take jurisdiction or not, or to leave it to states. So at the end, and frequently it asked states to prosecute because they don't have the resources enough. So it comes within the cooperation, international cooperation, which makes sense. It may cost, but it's part of a certain obligation towards the United Nations. The other issue was wondering if it does not concern Germany specifically, but if there are instances in which there is a claim that an investigation should be made on international crimes that would come into the jurisdiction of the ICC, is there any mechanism that this material, when the decision is made not to investigate, goes to the court? Not because the court should decide on the investigation, of course, it's not an appeal, but that the court be informed. Has the court put any in place any mechanism to get, or is it left to NGOs if they wanted to raise, to bring the things to the court, for the issue to the court. But this could concern any state, I mean, not Germany as such.
Thank you very much. I don't know, we want to make a quick final round, or you want to, Wolfgang, noch was zu den technischen Fragen?
I'm not sure if I got the last question correctly. Just very briefly then, with regard to this case of the former Rwandan mayor, this is maybe it wasn't a good example for how the cooperation with an international criminal court could or should work. The accused Onesphore Bukombe was, even though he was a mayor of an exile community, so a powerful figure, he was not one of the main, you could call it, perpetrator. In the end, he was sentenced to life imprisonment as a co-perpetrator, but the main guy in the massacre was Gakombitsi. And the whole legal assistance issue, whether Gakombitsi would testify, in the end didn't work out at all. But Ruwe Bukombe himself was never an interesting figure for the ICTR, so there was no case before the ICTR initially against Ruwe Bukombe. So, yeah.
Okay, so if you allow me just one final sentence to in a way, point to our further deliberations here in this conference. So, I mean, if you, what may we take from this perspective on the German example? So, if I just try to summarize a little bit in one sentence the discussion and the issues you raised. So the one is the role of civil society, which is very strong, I mean, as we know in the Rome Statute drafting, but obviously still in the practice. I mean, that's I think what we can take from Germany. The second issue is the key role of the prosecutorial discretion, which we, as you know, in Germany in the criminal procedure, we don't have, but we have for crimes committed abroad generally. It's restricted for these crimes, but there still is discretion. And the way, how, and under what circumstances, and the political issues which Wolfgang raised play actually a key role in our debate. But still, we should not forget what Leonie Steiner mentioned, and that this is what we mainly discussed with regard to Italy, that also in terms of substantive law, substantive criminal law in our code, there is a debate about reform and about shortcomings and about not, I mean, as partly as a consequence of this modified codification approach we had, which doesn't really fit anymore with the developments on the international level and with other things. So just to, I mean, for myself also to take something for our further debates when we then go on and look into the specific areas. Thanks very much to all the panelists. I think it was very good. Thanks very much to the online panelists.